Good afternoon, members. It's already past 4:30, and we have a quorum. The meeting of the Bills Committee on Stamp Duty Amendment Bill 2012 is now called to order. Agenda item number 1. We'll continue our discussion with the administration. As usual, I declare interest. I own property, and I'm an accountant. My employer does provide tax advice, and on the stamp duty bills 2012 and 13, my employer does provide its view, but I'm not involved in that. Well, Mrs. James Chen, I make my declarations I did in the past. Ms. Ann Chang, yes, I made my declarations I did in the past. Mrs. Regina Yip, I own property. Mr. Tony Chair, yes, I declare, I now declare what I did declare in the past. Mr. Kenneth Leung, yes, I declare what I did earlier, and my employer does provide tax advice, and I do provide tax advice. Mr. Ronnie Tong, I repeat my declaration. Mr. Ronnie Tong, Ms. Ellen Leung, I repeat my past declaration. Mr. Pun Siu Ping, I own property. Mr. Yu Siwing, I repeat my previous declaration. Ms. Abraham Sheikh, I represent the real estate functional constituency. I own property. Mr. Jeffrey Lam, I own property in Hong Kong. Is it enough? You repeat your previous declaration. Mr. Chen Kam Lam, Madam Chairman, I repeat my previous declaration. I own property. Well, my apologies. That is the advice given to me by the Secretariat, and that the only thing I can do is to adhere to this arrangement until there is a new arrangement between the Secretariat and the Committee on Rules of Procedure. We have started our discussion on the Administration CSA paper CB1 1719 1213 bracket 01. We discuss the revised mechanism to refund the buyer's stamp duty for redevelopment projects. Members did provide some advice and also raise some questions. Let's continue our discussion, and I'd like to ask the administration to make certain supplement to this paper, and let's see whether other members have any questions. Agnes? At our last meeting, members asked about the details of the revised mechanism for redevelopment projects. And in fact, we have provided the details in paper CB1 501314 bracket 01. At the meeting, members asked, in respect of the revised mechanism, which is based on two major principles, the developer has to own 100% of the whole lot. Number two, there is evidence that there is intention for redevelopment. There are two choices, two possible pieces of evidence. First, obtain approval from the building authority in respect of general building plan for the redevelopment, and demolished by building exist on the lot, or obtain consent from consent to commence any foundation work by the building authority. Members ask whether just one of the conditions will do or A will do. There are different circumstances for the sites for the redevelopment. Therefore, we want to provide flexibility to the developer. The condition for any foundation work is one of the conditions. Theoretically speaking, there should have been a building plan approved for redevelopment, but some sites may be very big, and there can be phased development by the developer. So this is a faster track. We do not rule out the various conditions and development procedures by the real estate developer. As members want to give flexibility to the developer so that the developer can get back the refund for BSD, we provide these two conditions as an either-or situation or condition. The second question is about a developer meeting the requirement and has obtained a refund on the BSD for one reason or another. The developer wants to sell the site to another developer, and that developer is also in line with the redevelopment requirement. The new developer is able to get the refund of BSD. We want to explain that the intention of the refund mechanism is not to stand in the way of redevelopment, and that's the concept for raising BSD. And that's a principle for raising BSD. As long as the developer is able to comply with the conditions for redevelopment, then the developer will get the BSD refund. That's the supplementary information we provide. So there is no change, basically. Mr. Tony Chair, 5 minutes each. Thank you, Madam Chairman. First of all, I thank the administration for clarifying the issues. Well, I understand the current arrangement, but I still want to raise 2 points concerning the refund on BSD. Will the administration consider simplifying the administrative arrangement? If one complies with the conditions, one can apply for the refund. Would you set a deadline, say if the application is after a certain deadline, then the refund will not be made? This will prevent something being hanged in the air, and or rather being hung in the air, and then for a very, very long time. So will you set a deadline? Say after that deadline, then no refund will be given if no previous application has been made. Now the buyer, of course, has to pay the BSD, and if he complies with the conditions in the paper, then he can apply for a refund. Last time I raised this point. I asked the administration to speed up the process of redevelopment. If the developer complies with the conditions, and if somebody has already obtained a refund and then sell the sites to somebody else, then the administration could consider this. The administration could consider not giving the refund of BSD for the same site. That's my suggestion for the administration. Thank you. The Secretary, is there a deadline? In fact, the revised mechanism is made in response of members and also the stakeholders. We want to speed up the process of redevelopment. We are willing to make the amendments because we want to see redevelopment. We are more lenient on this point, and we want to speed up the supply of flats by redevelopment. If we set a deadline, then this may cause other adverse views. We may unnecessarily set up some hurdles. They have already paid BSD in advance. If the developer intends on doing redevelopment, he should start the works as soon as possible in order to get back the BSD. And that is the biggest incentive for speeding up the process. They've spent, or he has spent a lot of efforts buying up each and every flat over a long period of time. There is no intention for him or incentive for him to delay the redevelopment process. Well, if there is anything untoward, then that's another matter. And whether the BSD will only be refunded on one occasion for the same site. We want to see redevelopment projects going ahead. We may not rule out the possibility that a developer genuinely wants to conduct redevelopment, but because of some financial problem, the real estate developer can only sell his site to another developer, and that second developer is also genuine in respect of wanting to conduct redevelopment, and we therefore do not want to set it just for one time as far as the refund is concerned. If the developer has bought a site, he has done a lot of work on amassing the ownership, we don't believe that he will easily let go his property or his site. Well, I am in favor of being lenient. In fact, the BSD is unnecessary as far as redevelopment is concerned. Concerning redevelopment, do members have any follow-up? If not, then yes, Abraham Sheikh. I want to ask the administration. I asked the question, and I don't intend to filibuster. I don't say you're filibustering. Well, I'm not saying you. I welcome the amendment. According to the government's policy, anything can be done. In fact, the administration has double standards. The developer is given a refund, but a permanent resident holding a company is not given any chance of refund. Investment is different from speculation, Madam Chairman. Urban renewal is an investment. An ordinary citizen buying a property and letting that out through a company is also investment. Many people buy property in order to get a rental income, and they don't do it through on an individual basis. They do it through a company. If the administration can trust a developer, why can't the administration trust an individual citizen? The administration has double standards. I don't want to put the Deputy Secretary on the spot. It should have been answered by the Policy Secretary. The Policy Secretary is very busy, so I just want to raise this question here. So you welcome the redevelopment arrangement, and we take note of your point. And when we go to clause-by-clause study of the bill, and when you introduce your amendment, you will have time to speak on your arguments. The administration, would you take us through the second part of the paper, Part B? In fact, we did introduce this part, and this is to exempt certain acquisitions of replacement property by non-Hong Kong permanent residents from the BSD. According to our bill, under certain circumstances, certain non-Hong Kong PR who bought property and then, or rather, who sold their property not because of their own volition, and they have to buy a replacement property, then they will be exempted from that. Having heard the proposal of the deputations, we also take note of similar situations, and that includes, say, the land resumption under the MTR, land resumption for drainage, so on and so forth. There are 5 of these situations. So in our CSA, we are going to add these 5 different situations.
Okay. So the land has been resumed by the government for public purposes, and if the property owner needs to buy a replacement property, he will also be exempted from paying the tax. So we have already explained that on previous occasions. Thank you. All right, technically, he will have to apply to you before he can get the exemption. Yes, he will have to state the grounds for acquiring this replacement property before he can get the exemption. So he will have to inform the IRD about this. That is, for these reasons, he will have to buy this replacement property. All right, moving on to C. Well, C is about admissibility of instruments not duly stamped with a BSD. That is, it will be accepted. It will be admissible in courts in certain proceedings. We have consulted the Law Society and also the Association of Banks. They both raised this because under the current arrangement, for instruments not duly stamped with stamp duty, it's not admissible in court. But then for the BST, it's somewhat different because it's the buyer who is responsible for paying that tax. But then if the buyer has failed to pay the BST, and if he has failed to pay the BST as a result of that, then when there is any dispute, then the innocent seller will have to come up with the instrument to prove that he is having a beneficial interest in the property. Then the CSA is saying that this innocent buyer or should not be affected, or this innocent seller should not be affected. That's why we have now come up with this CSA, and we've also put down the conditions that he will have to meet. That is for the instrument that has to be produced. Number one, it must not be the purchaser. It has to be the seller. Whoever needs to go to the court to prove this before the court, and also the purchaser must have made some misrepresentation resulting in his failure to pay the BSD, and that's in line with the comments made by the HKAB and the Law Society comments. All right. If there are no comments, then please move on. The rest is a consequential amendment. As members might be aware, under the Inland Revenue and Stamp Duty Legislation Alternative Bond Schemes Amendment Ordinance 2013, this is about Islamic bond, and on the 19th of July 2013, this bill was enacted by this council. That's because of certain types of Islamic bond or sukuk, we have to come up with some amendment provisions in the bill, and both pieces of legislation were tabled before this council at the same time, but then that one was enacted. But then as we are still scrutinizing this bill, that's why, well, the BSD was not included in that piece of legislation. That's why at the Bills Committee of that bill, it was agreed that once that bill was enacted, certain consequential amendment will have to be made to that ordinance, so that by the time when this bill is enacted, that would also be covered by that bill. That's why this is a consequential amendment. All right? Any questions? If not, then for the other parts, please. Well, other amendments are technical in nature, so they are just to improve the clarity of the bill, or they are just minor and technical amendments, and these amendments have nothing to do with the substance of the bill, and they are there to improve the reading and clarity of the bill, and I'll explain that when we come to that part. For example, it might have to do with certain wording in the provision. For example, replacing a with the word the. All right. So that's the text and also the spirit of the amendment. All right. If there are no further questions, then we'll move on to the clause-by-clause examination. Is that all right? All right. Members, let's move on to the clause-by-clause examination. I suggest we refer to the markup copy, as many technical terms are involved. Earlier on, we discussed with the legal advisor, and if we, what shall we refer to, the English version or what? All right, we can refer to the Chinese text then. Any objection? Okay, so we'll refer to the Chinese version in our clause-by-clause examination. All right, we can start now. Agnes, will you take the lead? Do I have to read that out? I think all you need to do is to explain the substance of the amendment in order to highlight the relevant parts that you'd like to draw members' attention to. Yes. First, Clause 1 is the short title, is the Stamp Duty Amendment Bill 2012, and that's the short title and commencement. And the commencement is the 27th of October 2012. That's the next day after the FS announced it on the 26th of October 2012, and that's the enhanced SSD and also the BSD, and that's Clause 1 of the bill. Yes, please move on. Clause 2, and that's Cap 117 Stamp Duty Ordinance to be amended, and that's set out in sections 3 to 18, so that's to highlight the parts of the ordinance to be amended. Yes, please. Clause 3, there are some interpretation clauses, mainly is to introduce the definition of buyer's stamp duty into the definition of stamp duty in such a way that buyer's stamp duty would also apply to stamp duty. That's why under Clause 3.1, so under the original stamp duty ordinance, we are going to add buyer's stamp duty into the definition of stamp duty. So that's subclause 1. Subsection 2, under Section 2.1, we add in the definition of buyer's stamp duty, and in a moment in the Schedule 1, bracket 1AAB, and also 1C, will be setting out the details of what buyer's stamp duty means. So, so the details will be set out in Schedule 1. All right, please move on. Next, Section 4, or Clause 4 in the bill. Under Section 4.3 is to spell out more clearly, that is by repealing certain words, that is stamp duty is not duly stamped, and substitute that with different wording. In fact, the purpose is to state that it spells out that well, both sides have the duty to pay stamp duty, and so both sides to the transaction will have this joint and several responsibility or liability to pay the stamp duty. But then under the legislative proposal here, in fact, for the BSD, who should be paying this and also who should be held liable for this is only the buyer who has the responsibility. That's why here we need to make a corresponding amendment so that the seller would not be affected because the seller has failed to pay this tax. So we have to spell out that the BSD is mainly the buyer's duty to pay. Any questions? I'd just like to know a bit more. Well, in terms of the actual enforcement, okay, it's the buyer who will be responsible, but then what if the buyer goes bankrupt? Will you be going after the bankrupt for the stamp duty or IRD? Thank you, Madam Chair. Should the buyer go bankrupt, we will have to go after the administrator of the bankrupt or the receiver for the outstanding stamp duty. All right, any further questions? If not, please move on. Clause 4.3 proposes that under Section 4.3 we should add a new clause 3AA, and it says that If any instrument chargeable with buyer stamp duty is not duly stamped in respect of that duty, the person or persons respectively specified will be held liable, and that would be the buyer, because for the buyer stamp duty, is the buyer who will have to pay this duty, and therefore, if he fails to pay, and if he has to be held liable, then is the buyer who will be held liable. And then we also go further to clarify that the reason why we have put in jointly and severally liable, that's with reference to those with joint ownership. In other words, there is more than one owner. For example, two parties might be buying the property together, and both will have to be held liable when it comes to the tax itself and also the penalty or the fine. And B also is the same, where there is more than one person being the buyer. Then if anybody has to be held liable, then both buyers will be held liable, or all the buyers will be held liable. Yes, please move on. Clause 4.4, that is to add the newly added 3AA. In other words, this amendment says that for the time limit for the BSD, for example, the AVD and also the SSD, they will be aligned. In other words, if we have to go after somebody for the BSD, then from the 6 years from the date on which the stamp is to be stamped, so that's to align with other forms of stamp duty. Mrs. Regina Ip, 6 years. Why 6 years? In other words, after 6 years, you will allow them to default? I don't understand. All right, I'll respond, and then the IRD can supplement if necessary, because under Section 4.5 of the Stamp Duty Ordinance, if there is any litigation or if we have to go after any party for the payment, then it says that it cannot be instituted after 6 years from the date of the stamping. In other words, the same arrangement will now be extended to the BSD. In other words, if you have to go after somebody, then the time limit will also be for 6 years. So is for the government, or is it the taxpayer instituting the litigation or the case with the administration? Is the administration going after somebody for the outstanding payment? So if the taxpayer fails to pay, and if the administration fails to go after him for the outstanding payment, then after 6 years, the administration will no longer be able to do it. But then, if it's owned by a private individual, and if there is a litigation, all right, if a member of the public does not agree with the administration, then he can institute a court case. Then does it mean that after 6 years he will not be able to argue with the administration about this? Well, I'll defer to the IRD. Thank you.
Say if a taxpayer has a dispute with the director of Inland Revenue, he will have to pay the tax first. And after 6 years, there can be no recovery. Mrs. Yip, now, if there is an appeal, will there be no appeal? Or rather, if one wants to appeal, then the appeal cannot be made after 6 years. Well, if the appeal is upheld, then the government will have to refund. But if it fails, in his appeal, he continues to JR, to seek JR, then is it subject to the 6-year limit for the ordinary citizen? Now, there is another provision. Section 14 provides that having received a tax assessment, an appeal has to be lodged within 1 month. What about my question? Say, if there is any stamp duty dispute among the citizens, it will not be restricted by this provision. No, it will not. You're right, Madam Chairman. Clause 5. This is to amend Section 29A3A. the interpretation and application of Part 3A. Madam Chairman, I want to raise this point. Now we have a 4A, which is the administration CSA. Shall we turn to that CSA? Okay, you may turn to that now. As for 4A, as we said earlier, say if one has not paid the BSD and the innocent seller wants the document to be admitted. In response to the view of the Bank Association and the Law Society, we have the new 4A to amend Section 15 of the Stamp Duty Ordinance. Now, under 4A1, we add Sorry, just a minute. Now, if you look at the markup, the Secretariat has provided a new set of markup, and that is 15, 13, 14, bracket 02. This is a bigger one, which has been distributed to members earlier. It is done by the Secretariat. Paper CB1, 15, 13, 14, bracket 01. What exactly is the number? CB bracket 1, 15 stroke 13 hyphen 14 bracket 02. The big one. The big one. If your assistant has prepared the paper for you, the big one. Do you have the relevant paper? We're on page 1 of that. 4A is in fact clause 15, the first page. The first page of the big one, the big paper. All right, if you found that paper, the Deputy Secretary. Yes, Madam Chairman. We have added 1B in subclause 1. This is to deal with BSD. Yes, please go on, Deputy Secretary. Now we put down the circumstances under which such documents are admissible in the court. That is under 1B. The scope is limited to several things. First, after the registration is made with land registry, it is found that the document has to be stamped. If you look at A, in case of a chargeable agreement for sale, our suggestion is that under the following circumstances, the agreement for sale is admissible. a small Roman 1. It was believed by the collector to be not so chargeable because of a misrepresentation made by the purchaser under the agreement, that the purchaser at the date of the agreement was a Hong Kong PR or was acting on the purchaser's own behalf, and the IRD is misled into believing that there is no need to pay BSD. And it is produced in evidence by a person who is not the purchaser for proving the person's title, which is under 2A, for proving the person's title to the property concerned. In fact, the document is produced by the non-purchaser. It is not for the purchaser to produce a document to prove that he owns the property, or the seller or vendor or the innocent seller who produces a document in court. These are the conditions in the amendment for putting the document before the court and be admitted and be admissible to the court. Condition B deals with conveyance on sale. The conditions are the same. One is for the S&P, the other is for the conveyance on sale. Conditions are the same. Okay, any questions from members? If not, then please go on. All right, let us go back to Clause 5 of the bill. Clause 5 of the bill is to amend Section 29A, interpretation and application of Part 3A. We propose to add Hong Kong permanent resident, Hong Kong permanent ID card, and also mentally incapacitated person. I mean their definitions. Later you will see why we need to add these definitions here. First, on the permanent ID card, to establish the definition is that it has the meaning given by Section 1A1 of Registration of Persons Ordinance, Cap 177. To put it simply, what is said in the Registration of Persons Ordinance is that one holds a permanent ID card, or on the face of the ID card, the person is a permanent resident of Hong Kong. This is to facilitate the IRD. When the person is able to produce such a permanent identity card, then the person holding that card is a permanent resident of Hong Kong. That's the evidence needed in implementing the new provisions. The second definition explains what is meant by Hong Kong PR under the bill. A, who holds a valid permanent ID card, that is clear, and B, who even if who doesn't hold a valid permanent ID card, but one is under Regulation 25E of the Registration Persons or Regulations Cap 177 sub-leg A, is not required to register or apply for the issue of an ID card. But if he wants to register, he is eligible to have this ID card, or who is entitled to have this ID card. Now, for a person who is a Hong Kong PR, as long as he goes to the the registration office, he will get the ID card within 10 days. Some persons who are permanent resident who don't need to have the ID card, because of the provision under the ordinance. Some people may, because of being blind, frail or old age may not be able to present themselves personally at the registration's office and therefore get an ID card. Under the registration of persons regulations, these persons are exempted from applying for an ID card, but if one feels the need to do so, then usually after one has applied, an ID card will be given within 10 days. Now, since these people are Hong Kong PRs, they are exempted under the bill. Mr. Ronnie Tong, I want to clarify this a bit further. Now, under this provision, is entitled to be issued with a permanent ID card. Is it the applicant who thinks that he is entitled, or is there a ruling already saying that he is entitled? Say if one believes one is entitled, but in fact the court later ruled that he is not entitled, then how can you deal with that? The Deputy Secretary. Now, concerning the elderly, the frail, the blind, they are not required to go to get an ID card. But the immigration office or immigration department does issue an exemption letter to the person. And if they hold the exemption letter or certificate, then they will be that will be okay. Why don't you put it in the law? Say those who hold the exemption certificate, instead of saying the person is entitled, the ultimate test is whether one holds the exemption certificate. Why don't you put it in the law? Madam Chairman, we need to define who is a permanent resident. If one holds the ID card, permanent ID card, that's very clear. There is another group of people, the number is not too many. They are in a different circumstances, yet they are Hong Kong PRs, and we put it down in the definition. Now, when the bill comes into effect, these two groups of people will be regarded as Hong Kong PRs. Chairman, I fully understand that. There is no dispute. The question is, in your drafting, you can say either they hold an Hong Kong permanent ID card or they hold an exemption certificate. That's the simplest way, and that's the most straightforward way. And there is no need to consider whether one's entitled or not. This kind of wording will only cause unnecessary disputes. The Deputy Secretary, will Mr. Tong's proposal be even more certain? I think this is also the point raised by some of the lawyers.
Madam Chair, can we ask them to go back and think about it? Well, is that okay? Go back and think about it, because all members are trying to do is to avoid dispute and conflict. Yes, I'll check it out and then I'll report back to this Bills Committee. Mr. Andrew Leung, I'm not interested on the provision itself, but then the explanation given by the Deputy Secretary worries me, because for a frail elder, all right, if I am an overseas citizen, then I can just ask a frail elder, and then I can just buy it without his authorization, and then I can be exempted from the buyer's stamp duty, and then I can also prepare a will on his behalf, so that when he passes away, then I'll be able to inherit the property, because this is going to be a major loophole, because all I need to do is to get many frail elders to sign all the instruments, and then they can buy the properties on my behalf, because I have the will and everything with me, so it's safe. And then this is a frail elder, and he will not be able to do anything about the property. All right. Well, as we are on that, I think this is going to be quite a major loophole that has to be plugged. Deputy Secretary, the reason why we have included this group of people, well, we are not talking about many people. In fact, they are all permanent residents of Hong Kong, and therefore, on the issue of fairness, we cannot just say that because they are frail and old, we can't say that they do not have any need to procure their own homes. And if they are permanent residents, then in order to be fair to all permanent residents as individuals, we cannot exclude them from this definition. That's why there is this principle of fairness being our primary consideration. All right, I'm glad that the Deputy Secretary is talking about fairness. But then, all right, if I go to an elderly home, and then I can just pay my relative tens of thousands of dollars so that he can buy the property on my behalf, and then I can have all the powers of attorney and will with me, then it'll be safe. So for the elder himself, he has no ability whatsoever to buy the property on his own. But then I can just take out $20 million cash, and then I can buy the property right away. So it's going to be a major loophole. And then you talk about the principle of fairness, of course, is good. But then you have not really checked the relationship between the buyer and so on. All right. Well, there is a fake marriage. All right. Whenever you have such laws in place involving millions of dollars as tax, then people are bound to take advantage of these loopholes. So you will have to be careful about this. Deputy Secretary, all right, we will have to go back to the original intention. When we try to exempt permanent residents buying property in the personal capacity, so we want to exempt them. And another group of people, they are also permanent residents. I cannot just make second guess that they are very innocent and they could be taken advantage of by other people. So we cannot just jump to that conclusion. Yes, I understand what Mr. Leung was referring to. He was referring to companies. So how come you're saying that, all right, for company directors, they are so innocent and they could be taken advantage of, or they could be made use of in buying properties? Yes, as we have explained, well, companies and individuals are very different entities, and then we are talking about this group of people who are also Hong Kong permanent residents, and it will be hard to justify why some permanent residents can do it and others cannot if they are all buying properties in a personal capacity. That's why when we consider the situation, we try to consider it from that perspective. That's why inevitably for these people who are also Hong Kong permanent residents, we will also have to ensure that they can enjoy the same exemption. Mrs. Regina Ip, then my question for the Deputy Secretary. Well, there are people who have the right of abode, all right, they have not got the permanent ID card, all right, they are below 11 years old. What if I buy this property on behalf of my newborn or my infant child? So can I just buy this because he is not able to sign the document? So for those under 18 or under 11, what happens? All right, in the later provisions, all right, for the minors who have yet to reach the age of 18, but then if they are also permanent residents of Hong Kong, then they would also be able to buy property through their guardians. But then for this individual, he has to be a Hong Kong permanent resident in the first place. So this status will have to be established first. In other words, his guardian will also have to be a Hong Kong permanent resident. Is that right? Can you clarify that? All right, in the later provisions, we will be covering that too. That is, we will also be talking about the mentally incapacitated person. All right, for a minor, he is not able to sign any legal instrument. But then if he is a Hong Kong permanent resident, then under specified circumstances, he can ask his guardian or a trustee to do it on his behalf. But then the most important thing, the property is owned by this Hong Kong permanent resident, and under the circumstances, he will also be exempted. I think the I think the most important consideration is whether or not this individual is a Hong Kong permanent resident. So for custodians or guardians, do they have to be Hong Kong permanent residents? Well, we haven't covered that because the most important thing is that the property has to be owned by a Hong Kong permanent resident. That's the most important consideration. Yes, Mrs. Regina Ip. Sorry. I'd just like to go back a little bit because I have missed out on clause 4. It's about the charging of stamp duty. All right. So the stamp duty is to be jointly and severally paid by the buyer and seller. So both will have to pay 15%, right? Oh, I didn't hear it just now. All right. For this minor, he will have to be a Hong Kong permanent resident before he can get the exemption. But then for a minor, he is not allowed to sign any legal instrument because he's underage. That's why, under the circumstances, we will allow his guardian or his so-called trustee to deal with such legal proceedings on his behalf. But then, legally speaking, this property has to be held by a Hong Kong permanent resident before he can be exempted from stamp duty. All right, Deputy Secretary, what you're saying is for the trustee or the guardian, they do not have to be Hong Kong permanent residents. There is no such requirement, and that would also constitute a loophole. Would that be the case? All right, for a non-resident, well, he can be a guardian or a trustee of a minor who is a Hong Kong permanent resident. Then he does not have to pay tax. At least he'll be able to stay in that place until the time when this minor reaches 18, right? Well, if the intention is to take care of Hong Kong permanent residents buying property in their personal capacity, then in special circumstances just now, because of his age or because of other circumstances, he is not able to sign the legal document, then under these circumstances, we would allow somebody to do it on his behalf. And we will also have to establish that the genuine owner of this property is a Hong Kong permanent resident. But then, Deputy Secretary, you will also have to think about this loophole, even if you're not able to give a ready answer. Well, I can also supplement. Well, for the guardian, he cannot be anybody. So IRD may perhaps be able to supplement on that. Well, just now, some members are just raising some possible loopholes for you to consider. You will have to think about it as a package. How do you deal with that? Well, IRD colleagues, please. Thank you, Madam Chair. What we have in mind is if a guardian is to become the agent of the minor in buying a property, he will have to produce all the documentation to prove his status. For example, he is the guardian of the minor, he's the parent of the minor, or the agent would also have to make a declaration that is the property is beneficially purchased or acquired by the minor. Well, there might be many loopholes because we have many children with non-Hong Kong parents, and they can also have their close relatives or relatives as their guardians. So please think about it, because for children with non-local parents, so their parents can also buy properties without having to pay the BSD. But then for children with non-local parents, they are also Hong Kong permanent residents. That's the consideration. Well, Anqiang, well, that's what I have in mind. You may not have to answer this because I've also received news that is for minors under 18. They are not regarded or treated as Hong Kong permanent residents. So if you have several children, we joke that actually you can also use their names and buy several properties. Well, even for the mentally incapacitated, well, you said that so long as somebody can get hold of his ID card and then they can buy property using their names, I think it's going to be a major loophole because for minors and also for really frail elders, there is no way that they can check the documents because he has to sign on many documents, and one of which will say that, all right, I understand that the IRD has already prepared this document. That is, he will have to make certain declaration. That is whether or not he is a permanent resident, and then whether or not he owns another property and so on. So you have to make many declarations. But then for frail elders and also for children or minors, how can they sign on those documents? And then for a guardian signing on their behalf, or after the guardian has signed on the document, will he or she be able to represent the minor? To what extent do you know that minor? And also, where does the money come from? So I really think that this is something that really has to be looked into. Well, they do not have to give a reply right now. After the meeting, they will have to look into it before we can come up with a reasonable set of provisions. Yes, they'll have to think about it. Yes, Tony Chair. Thank you, Madam Chair. I would also like the administration to think about it. It's about a Hong Kong permanent resident. I think this status means that you will have to meet certain requirements before you can be treated as a Hong Kong permanent resident. All right, you hold an ID card. That's the clearest way to prove that you are indeed a Hong Kong permanent resident. But then what about others who have yet to get such an ID card? And also there might be exemptions for them to get such permanent ID cards. So my understanding is because of their identity, if they can meet the definition of a Hong Kong PR, then they will be eligible. That is, they will be exempted from paying the BSD. As regards the ID cards, all right, that's one of the documentation that can prove their identity or status as an HK PR. Can you clarify that or confirm that, Deputy Secretary? I think Mr. Chair's concern is correct. That is, all right, if you hold an ID card, that's very clear, but then there are other people, well, they may not necessarily be able to produce an ID card. And then for the circumstances that we just set up, taking into account the fact that they do have this entitlement if they want to do it, and therefore we are not just casually asking anybody to do it on their behalf. That's why whether or not it's the trustee or a guardian, well, there are certain requirements that they will have to fulfill. So it's about how we view this issue. Well, even for children of with non-local parents, well, they themselves are also Hong Kong permanent residents. And this is something that we cannot deny. That's why, from that perspective, we believe that under the bill, for this group of people, they would also be allowed to buy Hong Kong properties. That's why. That's because they are also Hong Kong permanent residents. As to how we can work out a system or something that would be easier to enforce, we'll think about it. But then without the ID card, who is going to decide whether or not he is a Hong Kong permanent resident? Is it the Immigration Department? If there are any inclarities, then the IRD and the Immigration Department can be asked to double check. So in case there is any doubt, we can always ask the IRD and the Immigration Department to confirm or verify. So whose responsibility is this? All right, the buyer will have to prove its status, and if the IRD has any doubt about it, then the IRD will check with the Immigration Department. All right, Abraham Sheck.
We can see that this is a very scary situation. The bill has so many problems, and she is not able to answer all the questions. Now, Article 24, the basic law, is very clear. It spells out who are Hong Kong PRs and who are not. There are provisions. Article 24, 1, 2, 3, 4. Look at the basic law. And there is the definition. And I'm happy to hear that they have the rights. They are the HKPRs. The basic law doesn't mean Hong Kong PR. The basic law only mentions Hong Kong residents. Now you have experts. Seek advice from your experts. I also want to tell those parents, mainland parents, whose children were born in Hong Kong. This is a loophole. Mr. James Ho has mentioned that their children who were born in Hong Kong can own property in Hong Kong, and these parents can own property on behalf of these children in Hong Kong. This is a loophole. We have been talking about it for 7 months. Mr. James Toes raised that. Who can be a trustee? Any Tom, Dick, and Harry. And even the IRD is not able to answer this question. You really need to go back and think about it. I dare not ask you to do so, because other people will say that I am filibustering. We need to speed up the process. We are speeding up the process. In the past 7 months, we asked you to speed up the process, but you are not able to address the questions. You just can't address those questions. We hope that you will consider the possible loopholes and how to deal with them. And please come back and address this point. Mr. Lam Tai Fai.
即係剛才秘書長都講啦，即係永久性嘅居民其實人。
Hong Kong PRs are all equivalent, be they mentally incapacitated, or be they children, or be they adults, they should be treated equally. Because they are minors, because they are mentally incapacitated, they need to get a trustee. And the IRD says that there is supervision on trustees. And we'll ask you how you supervise those trustees. And members have pointed out this particular loophole. Now, this is only a loophole considered by members. I want to ask the Secretary, do you admit this is a loophole? If you don't admit, or if you admit, will have a very important bearing on the issue. If it is not a loophole, then you don't need to pay attention to that. If you think it's a loophole, then you have to deal with it. When you buying property with companies, you say there are a lot of loopholes. If you admit this is a loophole, then if you don't deal with it, then it's unfair. I want to get an answer from you. Is it a loophole, or is it not? If you say it is not a loophole, then we deal with it as if there is no loophole. But if you think there is a loophole, then we need a special meeting to discuss how to plug this loophole. Well, it's not just a question of yes or no. We give exemption to HKPRs for 2 reasons, on 2 conditions. Number 1, the person has to be HKPR, and we cannot rule out the possibility that HKPRs want to buy a property for their own accommodation. The HKPR is very different from a Hong Kong company. It's not about an investment need. It's about accommodation need. We cannot rule out the possibility that Hong Kong PRs don't have the need to buy a home. It should be fair to everybody. We have to allow that group of people to own property. They are HKPRs. If they want to buy a property, then we see no reason not giving them exemption from BST. I have 5 minutes, so I can follow that up. Is it because a person is HKPR? Then even if there is a loophole, you still go ahead with it. You have not answered my question. I know they are HKPRs, they have the right. But will there be a loophole? And if there is a loophole, and you still go ahead, even if there is a loophole, despite the loophole, you still go ahead with it. That is overriding, even overriding the loophole. Answer my question. Is it overriding the loophole? Well, let her answer the question, Mr. Lam. The consideration is Hong Kong PR. They have to be treated equally. We cannot distinguish one Hong Kong PR from another. If there's a need to buy accommodation, then the HKPR should be exempted. And this principle of equality applies to all HPRs who buy property in their own personal capacity. Do you think that's a loophole? Do you think that's a loophole? Answer me. The Secretary. Members have pointed out that this is a loophole. Do you agree? If you agree, then you have to find out a solution. Madam Chairman, I've already said it very clearly. That's a really difficult point. The HKPRs have the right to buy their accommodation. Mr. Jeffrey Lam, the administration has proposed a bill, and we'll do our best to help the administration to perfect the bill. If there is a loophole, and if it creates an unfair situation leading to losses incurred by some Hong Kong citizens, that is not what we want to see. Say, for example, Hong Kong-born children whose parents are non-Hong Kong PRs, the Hong Kong children own property through their parents who are non-residents of Hong Kong. Can these parents be trustees of these Hong Kong-born children? Do they need to prove their source of income and how many children can they represent? One, to prevent horse race rigging, the rule requires that one person cannot own more than one horse. We have yet to come to this clause, but we have found a lot of problems. I think the Deputy Secretary has to give us a very detailed explanation concerning the trustee. What is the definition? Do you think there is any loophole here concerning the definition of the trustee? The Hong Kong PR, what do you mean? Say, the trustee of Hong Kong PR. Hong Kong PR definition very clear. If he is born in Hong Kong, it's Hong Kong PR, or one has lived in Hong Kong for so many years, one is a Hong Kong PR. He doesn't buy the property, but he buys through a trustee. And the status of the trustee also involves a legality issue. How can you clarify this legality? The Deputy Secretary, in terms of implementation, the IRD will supplement, if if necessary. Now, concerning the minors or mentally incapacitated persons who are HKPRs, under such circumstances, we allow them to buy properties through the guardian or trustee. The law does not have any provision for the eligibility of the trustee or custodian. The IRD looks at it from with common sense, and if there is anything which is abnormal, the IRD will follow the matter up. If we are to make further division among HKPRs, that will cause unfairness. If we look at the provision, say if close relatives or next of kin or spouse, one of them is and they jointly own a property, even if one is not a permanent citizen, then we still exempt the BSC. Madam Chairman, I asked her this. Say, if a Hong Kong-born child who is 3 years old, I'm not talking about husband and wife, it's about the guardian. Are there any requirements on the guardian? The IRD will supplement. A guardian, we mean the parents usually. If it is found that somebody becomes a trustee of many children, in holding many properties, then the ILD will have to follow up. Perhaps the ILD can supplement. Yes, the ILD in terms of implementation. The Hong Kong born children of mainlanders are Hong Kong PRs, and we cannot exclude them from buying property. But how can you avoid such abuses? In terms of guardianship, Mr. Lam has raised several questions. Would you require them to be parents if they are to hold property on behalf of the child? Any supplement? Do you need to go back and think about it, IRD? We have nothing to add for the time being.
出嚟呢個問題咧，就唔係話呢個係一個
Now the administration has to take note of this. There is a shortage of property or a shortage of flats in Hong Kong, so the law is not there forever. It is a special arrangement for a special situation, and if the property market has calmed down, then this provision can be withdrawn. Now, this is a special situation. We don't want people to get through the loophole. Mr. James Toh. Madam Chairman, I understand the point raised by the administration in respect of clauses 8 and 9, or subclauses 8 and 9. I'm referring to 29CB, markup copy, page 29, say the trustee may be a trustee of a minor. That is a really big loophole. Say a Hong Kong born child of mainlanders, Hong Kong born child of mainland parents, Hong Kong born child with mainland parents. He has got a birth certificate. Now, the child is just a baby. I'm a speculator. I go to buy a property. I know this. I buy the property on behalf of that child. Now, I don't know how you implement subclauses 8 and 9. Do you require the consent of the parents? Say, I'm the uncle. I can buy a property as a gift for my nephew. Now he is just a few months old, and he doesn't know that, and his parents even his parents don't know that. And after several years, then the price of property has gone up, and then I sell the property. I rely on para 9, subclause 9. I bought it on trust. I sell it on trust. And the money cannot be put into the account of the child, so I put the money into the account of the adult. And I get away with it. Not even their parents know that their child has a property. I'm a relative. And you don't need to be a relative. The Hong Kong-born child with mainland parents may have already moved to Hebei.
But then you may say that well, there is a risk because assuming that this Hong Kong baby with non-local parents has grown up. All right, everything is registered with the land registry. All right. You can always go after this speculator, all right? They've never asked you to buy the property, and you have done it on their behalf without their knowing. And everything will have to go back to the permanent resident, who is a baby. But then they might not be aware of that at all. All right, even if I were the parent of this Hong Kong-born baby, there is no way that I can check with the land registry every day. So this is a loophole that cannot be plugged. So they can complete the transaction without the permanent residents knowing. nor will his parents be able to find out. All right, for guardian, it's easier because you can cite an example. All right, well, you will have to go to the court to appoint a guardian. But then for trustee, he can be anybody. All right, if I buy a property, if I say that I'm buying this for this permanent resident who is a Hong Kong baby with non-local parents, so any baby at all. So let's just forget about this. All right, if somebody wants to buy a property using my son's name, all right, it can cost $300 million without my knowing. There is no way that I can find out. Unless there is some nosy property agent finding out that, all right, this property is under the name of Toshan Chi, that is my son's name, then I will have no way to find out. So this is a major loophole. All right, I'm not suggesting that there should be no parity treatment, but then you will have to plug this loophole, or else anybody who has the particulars of a newborn baby will be able to do so without the baby's knowing or his parents knowing. So I've already told you how it can be done. I've already given you all the details. I'm grateful to Mr. To for agreeing to the parity treatment principle. But then for the possible circumstances that may arise, all right, as different scenarios have been portrayed by members, we'll have to go back and think about them. All right, for those who have reservation about the cooling measures, please don't think that you've already discovered this black hole, and therefore you're trying to dwell on it. Well, it can be a loophole that cannot be plugged. Because if you look at the bill, under 1B, Roman 1, I'd like to know a bit more about this. What is the exemption about? Well, it's about Hong Kong permanent residents. All right, if they have ID cards, that's the best. But then what if they don't? Because I've also checked it out. Well, apparently for the frail elders, the blind, all right, they would be exempted because they might not be able to use the ID card. But then it can be a disabled person. Well, and also frail elders, they might become very precious bodies to buy property. So will that become a loophole? And also, as Mr. James To just said, in reality, once you have guardians or trustees who can make purchases on the minor's behalf, all right, there might be parents buying properties using their children's names, all right, then we can have this sort of trust. So the story will be complete. There is no need for them to prove anything, so long as he can use his money, but then the property is under his son's name. It's okay. He doesn't have to prove anything. But then several years later, whether or not the cooling measures have been lifted, well, after they have sold the property, the minor is still a minor. He will not be able to challenge the decision, and then he might only be able to find out years later. So will that become a major loophole? Meaning that you may have to take out or take away this exemption for Hong Kong permanent residents? Ms. Wong? Yes, Mr. Paul Chair's understanding is correct. That is under the Registration of Persons Ordinance. There are groups of people who are not required to take or to apply for permanent residence ID card. We are referring to the frail elders, the blind, and also the physically handicapped. They would not be able to go physically to the immigration department to apply for that, but then they will have this certificate with them. And if they want to get this ID card later, then within 10 days, they should be able to get such an ID card. Precisely because they are also Hong Kong permanent residents in terms of the status. That's why for parity treatment, any Hong Kong permanent resident trying to buy property in their personal capacity, he is entitled to do that. We cannot say that these people would not be allowed to do so. That's why you also refer to the Hong Kong-born babies with non-local parents. Indeed, they are also Hong Kong permanent residents. Because of their status as Hong Kong permanent residents, it's difficult for us to say that because they are somewhat different from those babies who were born in Hong Kong, they would not be eligible for this exemption. So we cannot say that this group of people will not be eligible for this. So this is the parity treatment principle. What I was saying was this is going to be a very major loophole, and you might, because you were concerned that for Hong Kong permanent residents held companies, they would not be eligible for this exemption. But then with this new loophole identified, you may have to come up with justifications to take away this exemption. Is that a possibility? Deputy Secretary, we do understand your principle of fairness, but then this is a major loophole. You will have to think about it. I think we also mentioned this on previous occasions when we designed the whole package. Well, initially, the ideal world is that nobody would be able to have any exemption, then there would be no loophole at all. But then we could also see that for permanent residents of Hong Kong, well, however volatile the market might be, they might still have a need to buy their own homes. That's why we draw a line there. But then once a line is drawn somewhere, then on parity treatment principle, what we just said, well, for people with the same status, it's difficult to say that they should not enjoy this exemption. But then under the current legal system, it's difficult to prove who's going to hold the beneficial interest, given the fact that this is a major loophole. So it's easy to abuse, and they will be able to evade the responsibility altogether. Yes, Wong Ting Kwang. Thank you, Madam Chair. Once a law is enacted, there is bound to be loopholes. And if you're doing this for these loopholes, then there are also fake marriages. Well, all they are, so they would be prepared to be married with people they don't know just for several tens of thousands. You can also see such ads everywhere. So in the future, in order to avoid the payment of SSD and BSD, I'm sure that in the classified post, there are going to be an upshot in such commercials so that people would be willing to become guardians and trustees of these people. So I hope that the Chief Executive C.Y. Leung can curb the rising property prices. But then, if we are going to have this loophole, it's going to deal a severe blow to the whole package. So unfortunately, what the other members said just now was right. So as parents, you can buy properties on behalf of these Hong Kong-born babies with non-local parents. You can also have relatives doing this. All right, you can also specify that only parents will be allowed to do so. But then, all right, if they have many kids, then they can buy many properties using their kids' names. And then for uncles, nephews, and so on, they would not be allowed to do it. So you will have to think about it very carefully, because with one piece of legislation enacted, you're actually creating more problems than solving them. And triad society might also be involved, and that could become even more serious a problem. All right, guardians and agents. All right, this will only apply to minors. Other members have also raised other concerns. Please go back and think about it. Yu Si Wing. I think for guardians it's really quite a big loophole. Well, what we are most concerned about would be for Hong Kong-born babies with non-local parents. So you might also wish to say that only where parents or both parents or guardians are also Hong Kong permanent residents will they be able to enjoy this exemption. That would also resolve the problem of non-locals making use of Hong Kong babies to buy properties in order to avoid the tax. So for one guardian, he is only allowed to buy property or be guardian of one child, or else one guardian could also be guardian of many children, and then he'll be able to buy many properties. So you will have to think about it. Or you can also say that only adults over 18 would be allowed to do so and enjoy the tax exemption. So, all right, Mr. Yu has given you some suggestions. All right, members are welcome to make suggestions, and then they'll go back to think about it. Lam Tai Fai. Thank you, Madam Chair. Obviously, many members have raised their concerns about this possible loophole, but then the Deputy Secretary has been using the argument of parity treatment in order to shirk or dodge the issue. I think you're just engaging in self-deception. I don't agree with what Yu Si-wing just suggested, that even for the guardians, they have to be Hong Kong permanent residents. Let's say if there is an overseas couple adopting a child from an orphanage, and then the orphan is a Hong Kong permanent resident, and then after the couple have adopted this child, well, they might wish to buy a luxury flat costing hundreds of millions of dollars for this orphan when he grows up. Then for the property costing hundreds of millions of dollars, well, the BSD might be very costly, even though the couple are very well off. But then they are just being charitable. How can you deny them from adopting children? So we cannot just say that only Hong Kong permanent residents or mainlanders would be allowed to adopt children. So in these circumstances, how would that be dealt with? Let's say a very rich Filipino adopting a Hong Kong permanent resident baby, and then he buys a property for this baby. Then would that be a loophole? So can you answer the question, or do you want to think about it? All right, I think we'll go back and take a look. And then the law will not be able to deal with hundreds of scenarios, but then I think we will have to go by the principle, and also if there is room for improvement, we'll be more than happy to look into it. Lam Tai Fai. I don't understand this. All right, we have been making suggestions as to how you can plug the loopholes in relation to companies held by Hong Kong permanent residents. You are not prepared to consider them. But then for individuals buying properties, there are so many loopholes, and yet you have refused to think about it. I think you will have to be very careful about this. You will have to give it second thought. And Chiang, I received a message. All right, somebody told me this. That is, they hope that the administration will pay attention to this. In fact, well, under many pieces of legislation, for minors, they are not allowed to do certain things, and there is no question of this parity treatment principle. That's why I think, Permanent Secretary, you will have to think about it. All right, Deputy Secretary, you're taking care of Hong Kong residents need to acquire properties, but then for minors, do they really have this need? So you will have to think about this if it's going to be a major loophole. Anyone else? Abraham Sheck. Deputy Secretary, I think there are several matters of principle to be considered. All right, for Hong Kong residents or permanent residents, they are raw. They should enjoy equal status and equal treatment. That's to be confirmed. And also, we will have to look at it from the parity principle. Yes, this is a normal circumstance, but then whether or not it's the BSD, BSD or SSD, I think is an ad hoc measure to deal with an ad hoc situation, because we're just trying to ensure that in the next few years, Hong Kong people will be able to acquire property for their own use. But then that's the legislative intent. But then, according to what you propose, the loopholes that we just spell out would go against the legislative intention.
I really want to cooperate with the Chief Executive C.Y. Leung to get this bill passed. Now, this can be implemented and then legislated due to the special circumstances. Members are blamed to be filibustering. I hope the administration can conduct a reflection on itself. The bill has a lot of problems. They have not thought through the bill before they introduce the bill. I have been a electoral member for 13 years. Apart from the land registration bill, this one is the second one, which is introduced without thorough thinking. I find it strange why the administration has not done its homework thoroughly. I raised many questions. You did answer my question, but the answers do not address the questions. It's not that we are filibustering. The administration has the duty to come up with a well-written bill. I want to put this to the vote as quickly as possible. I don't want to waste time. In fact, we have wasted a lot of time. Mr. Sheikh, every time when I speak to the media, I told the media that members didn't filibuster. We didn't repeat our questions. But when they don't answer our questions, then I have the responsibility to raise the question again. Yes, you please go ahead. I repeat the questions because they have not answered my question. They keep answering, but they don't address the questions. The Deputy Secretary. Now, we need to start from that principle. I don't want to repeat. The members are entitled to have different views, and of course, we'll go back and think about it. And that's a very important issue. You really need to consider how to convince members into accepting your proposal. Please address the question at the next meeting. Okay, we draw a line here on this part. Will we come back to this part? Yes, certainly. The Secretary, please go on. We were on Clause 5 of the bill. Now, there is another definition on mentally incapacitated person, and we follow the meaning of Mental Health Ordinance Cap 136. This is just an existing definition in another ordinance. These people have to be Hong Kong PR in order to be eligible to the exemption of BSD. But when you consider the question members raise, please consider the possible problems arising from the trustee of mentally incapacitated person. If the loophole is true for Hong Kong-born children with mainland parents, that will also apply to mentally incapacitated person. From subclauses 2 to 5 are consequential amendments. The conditions that are applicable to sales agreement, which are eligible to stamp duty, will also be eligible to BSD. Subclauses 2 to 5 are to extend the coverage of BSD to these conditions. Yes, please go on. Clause 6 of the bill is to amend Section 29B, the duty to execute agreement for sale. This is an amendment to Section 29B6, which says that stamp duty is chargeable on that agreement, which shall be deemed for the purpose of this subsection to be a chargeable agreement for sale, and that is to be done within 30 days. Suppose a person has not completed the transaction, the stamp duty ordinance requires the parties, be they purchaser or vendor, be liable to the payment of stamp duty. But the BSD is only the liability of the purchaser. We therefore have to amend the bill so that even if the person who fails to complete the transaction is the seller, he will not be liable to BSD nor any subsequent fines. And in Schedule 1C on the liability of BSD, it will be spelled out that only the purchaser will be liable to BSD. Whoever the person who is not able to complete the transaction, at the end of the day, it is the purchaser who has to pay the BSD. Will the administration explain that a little bit further? The inability to complete transaction, say one fails to complete the transaction, the seller refuses to sign, but if the seller refuses to execute the document, and then how can you go after the purchaser? Say if we have signed a provisional S&P, within 30 days, they should assign a S&P. Say if any party to the transaction fails to complete the transaction, then the side who fails to do so will have to pay the stamp duty and also the fine. But under BSD, it is still the purchaser who has to pay that. No, the transaction is not completed. There is no buyer nor a seller. Why should they pay? Say, I like this luxury apartment. I want to buy it. But he refuses to complete the transaction. Why should I pay? Why should I pay the BSD? Because I have not been able to buy that property. The ILD. Sorry, speaker's not coming through. Yes, please. The microphone is not on. Yes, the microphone is now on. Clause 6 of the bill is to amend Section 29B6 of the Stamp Duty Ordinance, and 29.6b requires the parties concerned to execute a S&P agreement to make it an agreement that has to be stamped. And under 29B6, if they do not do so, then they will be liable. Both parties, purchasers and vendors, are liable. But since the BSD is the liability of the purchaser, the part that deals with BSD will be the liability of the purchaser. The person who is liable will have to take up the responsibility under subsection 6. As for the question raised by Mr. Leung, it has been dealt with in another provision. Then tell me, where is the provision? The case is very simple. There is no transaction completed. If I have to pay the BSD, then I will have to pay 1.5 million if the transaction is 10 million. So I'm really being unfairly treated. To answer Mr. Leung's question, if the transaction is cancelled, he doesn't need to pay the BSD. Under the stamp duty ordinance, there is a clear provision. Now, two government officials have given me two different answers. Madam Chairman, my question, I hope the administration will answer it in writing. That is to give protection to everybody. If one official says this and the other official says that, then there will be a problem in the future. Legal advisor. Thank you, Madam Chairman. Concerning Mr. Leung's question, if I may supplement to see if that is really Mr. Leung's question. Say, if the seller, for one reason or another, does not execute the document, there is no transaction completed. This is not the duty of the purchaser. The purchaser wants to buy, but he is unable to do so. According to this bill, the administration says that or rather, according to this bill, they have to. The purchaser has to pay. The administration says under special circumstances, the transaction can be cancelled. Does it mean that if the vendor doesn't want to sell, then the transaction can be cancelled and BST can be waived? The administration, whether for one reason or another, if the transaction is not completed, then we will not charge stamp duty or BST on that transaction. So you don't spell out any circumstances under which a transaction is cancelled. As long as there is no transaction, there is no stamp duty, nor BST. Is it the case? Yes, correct. And do legal advisor have anything to add? No. Mr. Ronnie Tong, I think that is not just the situation of the BST. In fact, the stamp duty ordinance should have this provision. We are to amend the stamp duty, and we may not mention this condition. It should have been in the ordinance. It should have been in the ordinance. Can you show us the provision in the ordinance so that we know that provision applies both to stamp duty and BST? That is very simple. Somebody just quit, and or rather, the title is defective. Then the transaction cannot be completed. I think there must be some provisions in the ordinance, in the existing ordinance, which care for this situation. I know that we are not going to amend that part, but can you tell us where are the provisions in the existing ordinance? Thank you, Mr. Tong. They are Section 29C5A. 29C5 capital A. Can you tell us what it is according to your understanding? As said by Mr. Abraham Sheck, 5A and 5B. As I said earlier, if the transaction is not completed, then there is no need to pay stamp duty. Even if stamp duty is paid, the IRD has to refund the stamp duty, not just the BST, but also the stamp duty. So is it clear, Mr. Leung? Is your question answered? To play safe, give me a written answer. Okay. Well, your request is minuted. The administration, please go on. Mr. James Toh, do you have a question? Mr. Toh? Madam Chairman, page 26 of the paper, order of any court, is it just Hong Kong court? Who has answered this question? Sorry, markup copy, page 26, English version. Subclause 7. Say court order. No BST. Well, we have yet to come to that part, Madam Chairman. We have yet to come to that part. Can you briefly answer the question? Or shall we wait? Well, I think we already added. You're talking about trustee for minor. No. we were on the permanent resident part. It was at the front. Now concerning Hong Kong PR.
And also mentally incapacitated persons, MIP, and there is this concept of a family, but then there is no definition on a guardian of a family. I think the legal advisor has also asked this question. We have already raised this. Administration, can you supplement briefly? All right, under the company's ordinance, there is no specific definition on guardians, and the IRD would generally be dealing with that in accordance with the general rules. All right, they have this simple concept that is parents or whatever. So IRD, can you supplement? IRD? Yes? Ms. Lau? Well, to answer Mr. To's question, well, in the interpretation part, there is no specific definition for that. So we'll just follow the general practice in dealing with this. Just now, we have heard members' comments, so we'll go back and consider them together. Yes, we have asked the administration to consider this, Mr. To. But then, can I set out the details for this part? So are you referring to de facto guardian? That is, in reality, they are doing the job as guardians. Or are you referring to legally appointed guardians? So we have he has been appointed legally, because in some families, because of some complex reasons. All right, you're referring to MIPs. Sometimes they might be abandoned. So whoever is left behind, I'm not referring to the next of kin who might have abandoned them, but then those taking care of them might be somebody else. And therefore, for one reason or another, this person might be able to prove to you that he is taking care of this child or this person. But then you may have to allow for this kind of exemption. And on the other hand, you would also have to be prepared for loopholes, because when it comes to MIPs, it's easier to abuse the situation. My apologies for this. All right, I might be taking care of a child in order to save or get exemption from the BSD. Then I can use his name to buy this property, and then under the general understanding of guardian, so I can buy a property using his name without payment of BSD, and then he doesn't have the ability to go after me, so that I can transfer the property back to his name, and then I can just sell the property whenever I want, and then I can pocket the proceeds. So that's only normal. So you can say that this MIP might have been abused in the sense that his name is used to buy a property and nothing can be done about it, and other people will not be bothered. So de facto guardian and legally appointed guardians are very different things, and therefore you will have to take care of that. Yes, that point is noted. We have already raised that with the administration earlier. Any response from the administration? Not for the time being. All right. We have already asked the administration to go back and think about it and then come back with a reply. All right, still some time left. Please move on. Now we are on clause 7. It is to amend section 29C. It's about agreements for sale. And clause 712 is to include this BSD in the agreement for sale. So 1C is BSD. Yes, please continue. And then 7(3). So to add the words except for buyer's stamp duty, well, that's to add the name into the title. That is, if they want to add the names of other buyers or take out certain names. So with regard to the addition or deduction of names, then under 29C bracket 3 will be setting out the details. That's why under 29C bracket 5 there is no need for us to refer to the BSD, because with regard to the addition of names and also deletion of names, there is another provision which will set out the details. That's why this is a corresponding amendment. Mr. Sheck, where is the provision? Can you show us that? 29CB. And if you want to refer to that provision, it's under clause 9. So when we move on to clause 9, we'll be able to see it. Yes, please move on. And then subsection or subclause 4, 5, 6, they are along the same line. That is to include the concept of BSD, so that when it's applicable, BSD would apply. All right. Any questions? If not, then we have asked the administration to go back and think about certain issues and then respond to some of the concerns raised by members today. All right, I think we'll pause here. Yes? Clause 7. Anything or anything that members would like to raise? Well, just a reminder, date of next meeting, 28th of October, Monday, 2:30. All right, the meeting is now adjourned. Thank you.